I call this meeting of the Board of Adjustment for Tarpon Springs to order. Could we please have roll call?
Chairman King?
Here.
Mr. Cole?
Here.
Mr. Hassick?
Here.
Mr. Pavlou? Absent. Mr. Talarino?
Here.
Mr. Darby?
Here. Okay, we'll now move on to approval of the minutes for the October 24th meeting. After everyone's had a chance to review them, I will accept the motion.
If we take a motion, I just want to put a record here. The last time we held a meeting, it was mentioned that I was the vice chair, and there was some comment statement added in the minutes. Rodney, of course, stated that he would do a little housework and then get back to us, and we know we haven't done that yet. I'm still looking forward to removing my name as the vice chair.
Yeah, if I recall correctly, we had a question about, and that we were going to deal with that in some way tonight, I imagine.
When we have a full board, that was my understanding was that I believe at the time we only had 3 members, and we wanted to make sure we had a full board before we made or had the election of officers.
Okay, so are we going to be able to do that at some point this evening? At the end of the meeting, something like that? I mean, how does that?
It's just the prerogative of this board to go ahead and do that.
Right.
Okay. We will have an election for the vice chair after we consider all the applications.
Thank you, sir.
Okay. We'll now move on to the quasi-judicial announcement and the swearing in of speakers. I'll turn it over to the board attorney for that.
Please get approval of minutes.
All right, I'm sorry. I totally skipped approval of the minutes.
Okay.
Okay. As everyone has had a chance to review the minutes, I will accept a motion in a second.
I motion to approve.
Second.
I have a motion and a second.
Mr. Cole?
Yes.
Mr. Hassick?
Yes.
Mr. Talarino?
Yes.
Chairman King?
Yes. Okay, now.
Okay. This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial capacity. By law, it is the board's function to make findings of fact based upon the evidence presented at the hearing and to apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The criteria which the board must consider in reaching its decision is contained in the Land Development Code, and it's set forth in the staff report. And those are the only criteria that the board may consider in reaching a decision regarding an application. The board may only consider evidence that the law considers substantial, competent, and relevant to those criteria. Furthermore, the board can only consider evidence that's presented at this hearing in reaching its decision. If that evidence demonstrates the applicant has met the criteria established in the code, then the board is required by law to find in favor of the applicant. By the same token, if the evidence demonstrates that the applicant has not met the criteria established in the code, then the board is required by law to find against the applicant. The parties to this hearing are the applicant and the city is represented by city staff. There's an established procedure that will be followed at this hearing. All witnesses must give their testimony under oath. All persons testifying at the hearing must give their name and address for the record. All testimony and questioning at the hearing must address matters that are relevant and material to the criteria under consideration. City staff will go first and present its evidence, and the applicant will have an opportunity to cross-examine city staff and any witnesses that the city may present. Following that, the applicant will then present its evidence, and city staff will have an opportunity to cross-examine the applicant's witnesses. Absent unusual circumstances to be determined by the board, a party's opening statement and presentation should be limited to 10 minutes, though I would imagine the board would grant some leeway in complicated situations. At that point, the board will proceed to the public comment portion of the meeting. Members of the public opposing the application will be given an opportunity to present testimony. After all members of the public opposing the application have concluded, members of the public in support of the application will have an opportunity to present testimony. Each member of the public is limited to 4 minutes of testimony. A member of an organization or group, Following public comment, the applicant and city staff will have an opportunity to present rebuttal evidence and make a closing argument or summary. The applicant will go first, followed by city staff. Again, absent unusual circumstances to be determined by the board, a party's closing summary and rebuttal evidence should be limited to approximately 10 minutes. Following that, the board will consider the matter. At this point, does the chair inquires about ex parte communications?
You can go ahead.
Okay. I'd ask, at least for the first matter under consideration, which I think is the Allen matter, Tarpon Key, have there been any ex parte communications regarding Tarpon Key application?
Yes. I went out to the site after I read the letters from some of the residents and to address their concerns, and I called the planner for this development and asked him for some information. I never received any information from the planner. I got the information from the public records through Tarpon Springs.
Is that acceptable to the applicant? Any other ex parte communications? All right. At this point, is the book?
Yeah, so we're on to application 1262. He just did that.
That was the quasi?
Yeah, he did the quasi-judicial effort. We're doing application 1262.
Yeah.
Tarpon Key.
You need to swear in the witnesses.
Yeah, okay. Could all the witnesses who are going to provide testimony or evidence this evening please stand up to be sworn in? Yeah, go ahead.
I'm a lawyer, I can swear. You swear affirm to tell the truth, the whole truth, and nothing but the truth? I have affirmations all around.
Okay, so now would be the point in time where we're on to application 1262, Tarpon Key. Could staff please make its presentation?
Thank you, Mr. Chairman. Again, this is application 12-62. The applicant is requesting a waiver to the sidewalk requirement for the Tarpon Key subdivision. Tarpon Key is a 62-lot single-family residential subdivision located at 355 Anclote Road. It's the former site of the Lingalonga RV and mobile home park for those of you who've been here for a while. The applicant represents Ryland Homes, a national home builder whose site plan was approved by the Board of City Commissioners on December 18, 2012. Section 13201 of the Comprehensive Zoning and Land Development Code authorizes the Board of Adjustment to waive the sidewalk requirement if the construction causes undue hardship, is unreasonable, or is unwarranted. The applicant has provided a very thorough justification package that was included in your backup, and they concluded that there is insufficient right-of-way along Anclote Road and that requiring a 5-foot sidewalk is technically impractical. The applicant will, however, construct 4-foot sidewalks throughout the interior of the subdivision, but is asking for a waiver for the sidewalks along the perimeter. The entire length of Anclote Road is under the jurisdiction of Pinellas County and is constructed to a rural road standard with no curbs and open swale drainage. The land use pattern along Anclote Road is a mix of marinas, commercial buildings, single-family homes, and large vacant tracts of land. Land Development Code permits the Board of Adjustment to grant the waiver if one or more standards are met, and those are included in your staff report. The first standard is insufficient right-of-way width, and as you can see in the photographs that I provided in your backup, the area to construct a 5-foot sidewalk is reduced by the presence of drainage swales, utility infrastructure, jurisdictional wetlands, and clear zone requirements. Standard 2 is not applicable to this request as the road is already improved. Standard 3 applies a technically impractical standard to the request. The area between the edge of pavement and the property line is used for drainage purposes, as was previously stated. To construct sidewalks in this area, the applicant would encounter major engineering challenges that would entail the relocation of inlets, manholes, and the like, and establishing new grades for the drainage system. Furthermore, any impacts to the tidally influenced jurisdictional wetlands would require permitting and most likely mitigation from the jurisdictional agencies. Standard 4 is not applicable to the request. Staff has received email correspondence on this item, and those were included in your backup. The applicant's request and our determination has met review criteria 1 and 3. Therefore, staff recommendation is to approve the sidewalk waiver for 355 Anclote Road. And that concludes my remarks.
Okay, does the attorney for the applicant have any questions of staff?
Good evening. I'm Ed Armstrong. I'm an attorney at 911 Chestnut Street in Clearwater. I represent the property owner and applicant, Ryland Homes. I do have some fairly fundamental questions for Mr. Chapman. Good evening, Rodney.
Good evening.
Rodney, can you tell us a little about your credentials, your educational background, your professional designations, please?
Yes. I have a master's degree in urban planning from the University of Florida. I also have my certification through the American Institute of Certified Planners. I've been a certified planner for approximately 7 years. I have been here with the City of Tarpon Springs for a little less than 10 years. I have been involved in all aspects of planning. I drafted the city's transportation element of the comprehensive plan. I was one of the program project managers for the adoption of our multimodal transportation district, and I also sit as a member on the Pinellas County MPO's technical coordinating committee.
Okay. Are you intimately familiar with the comprehensive plan of the City of Tarpon Springs?
Yes, I am.
Are you intimately familiar with the land development code of the City of Tarpon Springs?
Yes, I am.
Are you considered by most to be an expert in the field of land use planning?
Yes.
My impression of your staff report is that very clearly is the opinion of the planning staff of the City of Tarpon Springs that waiver criteria number 1 and 3 support approval of this application. Is that a fair reading of your report?
That's correct.
In addition, is it your verbal testimony here tonight that waiver criteria number 1 and 3 are met by this applicant?
Yes.
Okay. I have no further questions.
Okay, you can go ahead with your presentation if you have one.
Thank you. Again, I've identified myself for the record. We're here tonight asking for a waiver of the sidewalk requirements. And as a matter of law, it's important to recognize that this is different than a variance case. A variance has a very different legal standard. This is a waiver case. And that goes to the criteria that's discussed in your staff report, that Rodney has discussed, and we're going to be discussing in our main presentation. But I ask you to keep that in mind. What your code says is the applicant meets any one of the 3 criteria, the waiver must be granted. We believe, as does your staff, that we meet 2 of the 3 criteria, and on that basis, the waivers should be granted. I'm going to introduce you to Cindy Terrapini, an expert in the field of land use planning as well. I'm going to ask her to introduce herself, describe her credentials, and then explain the factual justification for our request. Ms. Terrapini? To make it more efficient, why don't you explain to the board your professional background and credentials, and then explain the factual underpinnings for your professional opinion, which you will share with the board.
Good evening, Mr. Chairman and members. My name is Cindy Terrapini. I'm with Florida Design Consultants at 3030 Starkey Boulevard in Newport Richey. I've been a planner for 32 years. About a little over half of my experience is with the private sector and about a little less than half with the public sector. I've worked for the cities of Tampa and Clearwater and Pinellas Park, doing land use planning, writing zoning codes, reviewing applications, and now as a private consultant representing applicants such as this, writing elements of comprehensive plan, writing comprehensive plan amendments, pretty much all the elements of land use planning. I also have an undergraduate degree from Clemson University and a master's in urban and regional planning from Florida State University in Tallahassee. Before I start, if I might, there's 2 exhibits that I would like to refer to during my presentation. I'll pass these out. Yes, sir. As those are going around, just to remind everybody, I think you're well aware of the site. It is the former Linger Longer Mobile Home Park. It's on the north bank of the Anclote River. It's about 19.5 acres. It has extensive frontage on Anclote Road on the north and east boundaries of the site. Ryland Homes owns the property and plans to build a 62-lot single-family subdivision. And as Rodney mentioned, that subdivision site plan approval has been approved by the Board of City Commissioners in December 2012. We are now undergoing construction plan development on the site. The first exhibit, if I could refer you to the large colored exhibit, making the comments related to that.
Ms. Terrapini, if I could interrupt you for a moment.
Yes,
we have extra. Would you mind if we made these available to any of the citizens that are here?
That's fine. If you just give one to the clerk so we can have one added to the record.
Thank you. I'm sorry, Ms. Terrapini, please continue.
No problem. Thank you. The first exhibit illustrates the approved site plan, and this shows the 62 lots and the loop road that serves the project and Anclote Road on the north and the east boundaries of the property. I just want to make sure and note for you, and you can see it clearly on the plan, it's shown in purple, Ryland Homes fully intends and is committed to build a sidewalk on the entire internal roadway system of the project. It's 5,423 linear feet of sidewalk, which is over a mile of sidewalk within the project. The waiver we are asking for is not within the project, but on the edges of the property on Anclote Road. Again, the north and east sides of the property. As was mentioned, the criteria for the waiver is that there is an undue hardship, it is unreasonable or unwarranted, and the code establishes 3 possible conditions to evaluate whether or not the project would be eligible for the waiver. If one or more condition is met, any one, then the site is eligible for a waiver. We're going to demonstrate that 2 of those 3 conditions are met. The first criteria that's met is that there is insufficient right-of-way to install the sidewalk, and that additional right-of-way is not required by any governmental agency. If you look on the exhibit, the blue on the Anclote Road illustrates where there is a swale. And also on the pictures that I handed out, and also in the pictures in your staff report, you can see illustrations of that swale that exists along Anclote Road. In addition to the swale, there are utility infrastructure within there that also would conflict with the sidewalk construction. The right-of-way is extremely insufficient at the northeast corner of the site, and on the graphics that you have, this is highlighted in orange. In that area, the edge of the pavement is only 7.3 feet to the edge of the right-of-way. And actually, you need 15 feet to be able to make the sidewalk fit in. You need a 10-foot clear zone and a 5-foot sidewalk. So clearly, when you only have 7.3 feet and 15 is required, there's not adequate right-of-way at that corner. And that corner extends for some distance on each side. The second part of the criteria is that additional right-of-way is not required. As was mentioned, Anclote Road is a county road, and according to their comp plan, there are no plans to expand the road. This is not shown as additional right-of-way needed in the 20-year period of their comprehensive plan. The second criteria does not apply to the application since the right-of-way is already an improved road. The third criteria is that the sidewalk is technically impractical due to existing natural conditions. And this project clearly meets this criteria. In addition to the existing swale, the right-of-way is also burdened by an extensive number of trees in a wetland area. On the graphic you have before you, the trees are shown in green. Obviously, the green circles along there. Not only are there an abundance of trees in this area, for anyone who's been out there and seen the photographs, but there are significant size of trees that would prevent installation of the sidewalk without having to remove some or all of those trees. In addition, and due to the narrow width of the right-of-way and the tree location, because there are so many trees along there, it's really impossible to meander the sidewalk because of the trees in the root system. Again, those trees would have to be removed to be able to install the sidewalk. On the graphic shown in red is the area of the wetland that in the retaining wall along that eastern edge of the property. The wetland there is slightly on the property, extends into the right-of-way, and then it goes east across Anclote Road to the adjacent property and then south into the Anclote River. As was mentioned in the staff report, there is a tidally influenced wetland. So putting a sidewalk in there with the retaining wall that also exists would mean, first of all, swift mud permitting, possibly Army Corps of Engineers permitting, and the outcome of that would be unknown at this point in time, but clearly would represent some technical engineering challenges to be able to install a sidewalk in that area with those 2 issues there. In summary, the project site has insufficient right-of-way available to accommodate the sidewalk. The Anklet Road is a Pinellas County road, and the county comp plan designates this road as a two-lane undivided road with no improvements and no additional right-of-way required for the next 20 years. The existence of the trees, the swales, and the wetlands within the right-of-way are existing natural conditions that prevent the installation of the sidewalk within this area. Individually, any one of these natural conditions would create a problem, but taken together, these natural features cannot reasonably be overcome to allow the installation of a sidewalk. Again, the criteria in your code is that there is an undue hardship, it is unreasonable or unwarranted, and clearly I think we have demonstrated that the project meets all these criteria and a sidewalk cannot reasonably be installed in this area. On behalf of Ryland Homes, we respectfully request your approval of the sidewalk waiver according to your code criteria. Thank you very much, and I'd be happy to answer any questions that you might have.
Does staff have any questions for the applicant?
No.
Okay. Does anybody on the board have any questions for the applicant?
Yes, Ms. Terrapini, thank you for your testimony, and I appreciate it. Thank you for providing all of us with these photographs. I have some questions as it relates to your map here. Do you understand, if I'm looking at this, Street A, the main access to the proposed development, is that going to be gated?
The subdivision will not be gated.
Not gated, okay.
We do plan, let me clarify, there will not be gated. At the entrance, we do plan a perimeter fence or wall of some type, but there will not be a gate at Street A at the entrance.
Have you presented the plans for this perimeter wall or fence of some type to the city?
We have not submitted our construction plans yet to the city.
Do you, at this time, know what you are building as far as a wall or a fence?
You know, I'm not sure that, I don't believe that decision has finally been made yet. But
Okay.
there will be some sort of a perimeter around the project.
You have a red indication here of existing wetland. Can you tell me where this designation of wetland comes from? Is that from Swift Mud?
The wetland is has an approved jurisdictional line from Swift Mud. It has been surveyed, and Swift Mud has approved it, said that yes, that is the actual wetland line.
And there are indicators, and it has been surveyed as to where exactly.
Yes, I have the survey. If you'd like to see it, I'm happy to.
Oh yeah, if you can provide that so I can review it, that'd be great. Also, any other questions? I have more, but I don't want to hog it.
Does anybody else have any questions?
Two questions, please.
Yes, sir.
Not on this site plan that you gave us, but on the smaller one, the site plan, there's no dimensions on lot 1, where all the other lots, most of the other lots say they're 60 feet. Is that 60 feet there also?
The lots, we have a full set of plans. Let me look to be sure, but all the lots are at least 60 feet wide. Can you check lot 1?
Okay, so the reason I'm asking that question is, if you install a sidewalk, that would be roughly 6,000 square feet of impermeable surface along this road, right?
I'm not sure. No, a sidewalk is 5 feet wide.
Okay, so it would be 5,000 square feet of concrete where water couldn't get through, penetrate, and go down to the aquifer. It would run up on the road.
You mean talking about 5,000 square feet on one particular lot? If the lot is 100 feet long?
The length of the property is roughly 1,000 feet, is that right?
Excuse me?
What is the length of the property? What is the length of the property?
On Anklet Road?
Yes.
The east edge of the property? I really don't recall. I'd have to look it up.
I guess we don't really need to know that. What I'm asking is, if you put that much concrete along Anklet Road, what's your opinion, what would the effect on the water be? Would it go onto the road? I mean,
Can I try to help? I think I know where you're going. I think I might be able to help.
Okay.
Are you concerned about impermeable surface?
Yeah.
The water, the concrete, and the inability for the property to drain?
Right.
And I believe the answer is we're within the minimum ISR requirements, so we comply with code in that regard, even in calculating the area of the sidewalk throughout the entire subdivision.
Thank you.
Do you agree with that?
Yeah.
Sydney and Rodney? I thought that's what you were trying to get at.
Yeah. Thanks.
Okay, are there any other questions?
Yes.
Okay.
Okay, go ahead.
All right. The photo that you so graciously provided to staff board members and to the people present. The first one on the left clearly shows a manhole that is elevated above grade. Can you explain, or maybe it's a question for our engineer Rodney, why the county would have spent the money to put the infrastructure in for what's called an elevated manhole for what they had planned to eventually be met at grade with a sidewalk? With that knowledge...
I don't know how I can answer what the county may have designed, so I'm sorry, I don't think...
Well, it's clear, I think anybody can see that that manhole is above grade, which is done to allow for a future development and a future sidewalk.
I really don't think I can draw that conclusion. I'm not an engineer, first of all, so I'm sorry I can't answer that question. And what the county intended at the time they built it, I mean, we'd all be supposing if we tried to...
Ms. Terrapini, I'm just trying to get to your, you have told this board that, number one, undue hardship, and three, technically impractical are the reasons that you think that this request will meet. And as soon as I'm done with Mrs. Terrapini, I'll address you. Thank you. So, Mrs. Terrapini, my question to you is, if the existing infrastructure is there for the hardship...
I'm sorry. Say that
If the existing infrastructure is there for a sidewalk, I don't know that... I'm having trouble understanding how it's technically impractical.
There is no existing infrastructure existing for a sidewalk, because there is no sidewalk on the property today.
Right.
What I'm saying that the criteria that is met is the second one, that there are strict application requirement will be technically impractical in terms of engineering design due to existing natural conditions related to topography or the environment. Those include the swale that's existing, the trees, and the wetland and the retaining wall. All of those are natural features.
Okay, so are we to understand that it's your position is it's impractical because of the existing trees and swale, not because of the infrastructure with regards to sewer?
Well, what I stated is that there is also infrastructure there that is going to have to be accommodated if a sidewalk were put in, and the difficulties related to that are engineering, and if you'd like to hear from our engineer, he can certainly elaborate.
I would love to hear the engineering difficulties as it relates to the existing utility infrastructure.
If I may help in the legal analysis, we're not arguing that this is a hardship, but the hardship criteria, you have very specific criteria for the waiver of a sidewalk.
Okay.
And there are three different criteria. If we meet any one of the three according to your code, we're entitled to our variance, our waiver rather.
And your position is that you meet two. Can you tell us again for the record which two you meet?
1 and 3.
And one is?
The existing right-of-way is of insufficient width to allow the installation of a sidewalk, and additional right-of-way is not required under this code. That's number one. Number three, for strict application of the requirement will be technically impractical in terms of engineering design due to existing natural conditions related to topography or to the environment.
Okay. Thank you for clarifying that.
Any other questions?
I would just like to hear from an engineer, an applicant's engineer, regarding a little more in depth about the technically impractical due to the topography. Number 3.
Okay.
My name is Greg Wegener. I'm with Florida Design Consultants, 3030 Starkey Boulevard, Newport Richey, Florida, 34655. I'm a professional engineer in the state of Florida. Have been for over 10 years. I'm sorry, could you ask your question?
You want me to repeat the question?
Please.
I would like, this member would like more information in regards to number 3, technically impractical due to existing natural, whatever the rest of it was, conditions. Staff, can you repeat that?
The criteria?
Please.
I believe Mr. Talarino is wanting you to elaborate on the technically impractical standard in terms of engineering design. Just basically the challenges that you would face if a sidewalk were to be designed and constructed along the enclosed road right of way?
Starting from the south would involve the wetland crossing encroachment.
Okay.
Which is going to involve, again, Army Corps of Engineers and Swift Mud permitting.
Okay.
Their criteria involves, initially you have to prove that you can't avoid it. So it's avoidance, minimization, and then mitigation. So it's quite a process. It's quite a process.
Okay.
And then as we head north, we also
The
have...
permitting process is quite a process, is what you're saying.
The permitting process is quite a process, but it would be very difficult to get there.
Are you the engineer on the project?
Yes, I am.
Are you involved in the permitting process for the proposed stormwater pond inside of the development?
Yes, I am.
How far along are you on that permitting process?
Percentage-wise?
Yeah.
Probably 90%.
When you applied for the permit for the stormwater retention pond inside the proposed development, did you at that time apply for a permit to build a sidewalk on the existing wetland?
No.
Okay.
We did not propose a sidewalk.
Okay. And in your opinion, if you applied for the sidewalk permit, do you think you would have been as far along in the permitting process as you currently are for the proposed stormwater pond inside the development?
No.
You think you'd be farther along?
No.
Okay. Can you elaborate?
Can you explain to them who actually issues permits for stormwater ponds versus wetland mitigation?
Stormwater ponds are permitted by a city, and they are permitted by Swift Mud.
Okay.
Swift Mud looks at two different aspects. They look at stormwater systems, and at the same time they look at environmental systems, or environmental impacts.
Right.
We avoided environmental impacts on this project, and therefore didn't have to go through that extra series of justifications for environmental impacts off-site.
And as an engineer, in your professional opinion, could maybe instead of a variance to avoid a sidewalk altogether, could a sidewalk be built if it was built maybe without the code required right-of-way on either side of the concrete, or maybe width?
I'm not following you. There are other restrictions that physically prohibit it, specifically up by the intersection, and not physically enough space between the edge of pavement and the property to put a sidewalk.
I guess this board member's having a hard time understanding why we would go from sidewalk or no sidewalk based on the existing code and not meet in the middle and say, can't do a 5-foot sidewalk, we've got some right-of-way issues, can you give us a variance for the size of the sidewalk or the right-of-way? Kind of meet us in the middle. We still get our sidewalk as citizens in the community, but maybe instead of no sidewalk, we meet somewhere in the middle. I guess help me understand that from an engineering standpoint.
From an engineering standpoint, there physically is not space for a sidewalk in the northeast corner between the edge of pavement and the property line.
Okay, the
From
northeast.
an engineering standpoint, there is a drainage system in the roadway that is an open swale design.
Okay.
If I start taking up that volume by adding a sidewalk, it changes the whole nature of that roadway and the drainage system thereof.
Okay. So in your professional opinion, it's impractical, any sort of sidewalk, whether it meets the code required setback for right-of-way and size of sidewalk?
I believe it to be impractical.
Okay. Are there any other questions from any other board members? Okay. We'll move on, and we will hear anybody from the community who would like to speak against this application. If anybody wants to speak against it, please stand and come forward.
My name is Robin Sanger. I live at 36 Ada Street here in Tarpon Springs. I have a couple of concerns about this project, the least of which, or maybe the largest of which, is that Tarpon Springs is a walkable community. Everybody, including the residents who already have sidewalks, are not only responsible for the upkeep of those sidewalks, but any new developer is responsible for having that part of the system put into place. I look at the site plan and I see all different sizes of lots there. I'm wondering why some of those lots aren't just shortened to allow for a sidewalk. I think this is also a safety issue as people walk along that very busy road, especially at night when it's dark. It's a safety issue for the families and residents of the new development. I think that sidewalk is not an option. I think it's mandatory in our city. I think that that's what we've been working for in the city, is to change the codes to allow us to be a walkable community. So to me, this is a part of who we are, and it's the responsibility of a developer to not only understand that, but to make sure that his or their site is in compliance with that. Thank you.
Marty Peters, 1702 Heritage Oaks Court. I'm also chairman of the Budget Advisory Committee, and I'm speaking as an individual, not for the committee, but I do want to say to you that on the Budget Advisory Committee, oftentimes we have spoken in favor of economic development, and we want to thank this development for, I think it's safe for me to speak for the Budget Advisory Committee, even though we haven't voted on it or discussed this particular project. I'd like to thank you for coming to Tarpon Springs. We need your kind of development. On the sidewalks, though, I have to stand with Ms. Sanger. We have been pushing for a walkable community. I think as part of that economic development, any developer that comes in that helps build that infrastructure, such as sidewalks, makes the entire community more valuable for future development projects too, and hopefully you'll come back with another idea for another part of Tarpon Springs. I wonder, following along with what Mr. Calorino is saying, I wonder if there isn't some way that you could modify this, shorten some of the property lines, work out some sort of way in which you can have sidewalks, but they don't necessarily meet the standard code now. I'd like to work with developers. I'd like to see Tarpon do that. I'd like to see sidewalks too. And to give you an example of why sidewalks are important, I've walked most of Tarpon Springs a number of times. It's sort of a hobby. My wife was with me on one time when we were walking, and it got a little dark after we had been doing some campaigning, which some of you might be aware of. But got a little dark, and we moved off of the sidewalk into a place where there was no sidewalk. She fell, broke her wrist, and her wrist is still somewhat deformed as a result of that. The people that are moving into your homes, my hunch is they'd like to walk out of that community at some point, and it would be useful for them to have a sidewalk so that they could do that safely. I would hope that you could work something out. The argument that it's not practical to do it, I don't know. I see sidewalks on Old 19, I think Old 19, but definitely on 19, where they don't have the sidewalks, so they do some sort of wooden bridge over water areas. So it sounds to me like the impracticality of building the sidewalks is more about money. It might be somewhat difficult to spend all that money, and if you don't have to, then why should you? So hopefully something could be worked out so that you could get some sidewalks in there. I'm not sure about the 1, 2, 3, whatever. The idea, the concept of sidewalks, I think, are important for Tarpon Springs. Thank you.
Good evening. My name is Doris Walker, and my address is 1444 Starlight Cove, Tarpon Springs, Florida. I'm a fairly new resident here, and I love Tarpon Springs. But one of the things that excited me about it is it would be a walking community. I was very excited about that, and I think it's a safety issue. I'm happy to see development, as Marty is also happy to see development coming into Tarpon Springs. Very happy about that. I want to see Tarpon Springs be a built-up community even more than it is now. And I think it should be a safe community, and I'm very sorry about Kathy being hurt here because she's walking on a street and she's falling on a dirt road. I think that developers should look, when you make plans, I think you should look at the entire community. I think you should look at not just the money, not just the profit for the project, but also for the people. Thank you.
Is there anybody else who would like to speak against?
Oh, yeah.
Yeah, I'm Scott Underwood. I live at 1110 Marina Drive, which is just on the south end of the property. And I walk the road often and meet a lot of the people along the way. But I'll ask Rodney, how many times have you walked the road in the dark in front of that, linger along in front of there? How many times have you rode your bike there in the dark? Probably not ever. And that road is an industrial road. It's an industrial area out there. We're not talking about cars. We're talking about semis, tractor trailers. I was on the road. A car came about at 6 inches from hitting my dog, but on that wetland area where there's not much space there, I'm listening and there's no cars coming. They pass on that road. A guy passed and missed my dog by about that much on that road. I had, no place to go, but I ever walked in the morning down that road when the grass is soaking wet and 6 inches long. So where do you think people walk? They walk on the street. And I think that there was enough space that there could have been some planning involved and a compromise could have came up with. And I guess to me it kind of tells you maybe what kind of developers you look at, of people that really want to help the community or trying to build it as cheap as they possibly can. Rodney, how many lights are on that road? Street lights, do you know?
Again, it's a Pinellas County road. They have
It is. It's a Pinellas County road. There's 0 lights. Did you know there's a bus stop on that road? There's a bus stop right on that corner. Anybody that lives in there that goes to a public school is going to have to go to that bus stop. They're going to walk along that road. So they're going to bring those people in, increase the traffic, not put the sidewalk in, and then also the heck with the people that move in there. They're going to have to walk out on that road. Any kid that goes to school, the bus comes in the dark. I've got a person lives in our development, Mike Pace. He's a grandfather taking care of 2 kids. His son's just going into high school. He's got a daughter a gal, he's 7 years old. He has to leave her. He leaves her at home, takes the son out in the dark to the bus stop because he won't let him walk down the road. Leaves the 7-year-old by himself at home. And I mean, a lot of the people that really use that road, they're not here. They're not the people that they're going to come to the meeting. The other thing I'd say is, have you been to the Work Release Center, the Prisoner Work Release Center that's located over in the woods there? Most people don't even know about it. They are required to take that road to work there and back every day. There's 48 of them. Almost all of them have bicycles. There's over 150 bicycles that go down that road every day. Those prisoners go down that road every day. They go to work twice. Most people don't even know it. They've never been over there.
So I'm sorry. Can you repeat your first name for the record?
Scott Underwood.
Scott, thank you.
Those prisoners, I've talked to the guard there. If they go off of that road, they can be sent back to prison. They are required to take that road every time they go to work, and almost every one of them works at the sponge dock. I see hundreds of bikes going on that road. Go walk the road sometime at night, ride your bike there at night, and decide if you think we need a sidewalk there. It's a crime. If I was a good developer, I'd be calling Pinellas County to get some lights out there to make it a little bit safer. Thank you.
I would just like, I'd just like to remind everybody that procedurally we need to keep all comments to 4 minutes, and then you can come back and make comments as we move forward. So, thank you. Please continue.
My name is Dan Clem. I live on Center Ave. A few of my neighbors are here. What I'm more concerned about is, as everybody knows, that street is always flooded. Just like the gentleman said before, if you walk off the road, you're walking in water. Center Ave is basically a retention pond for Ancoat Road. My concerns are the curbing and sidewalks and drainage. Is that also going to come down Ancoat Road and come down our road? Because right now I get a foot of water every time it rains real hard. And the city says it's not their road, but it's the city's water. And what would this be? I'm real worried about getting more water.
Thank you.
All right. Does anybody else want to speak?
Good evening. My name is Greg Liston. My wife Karen and I live on Center Avenue in Tarpon Springs. Actually, I kind of want to, repeat the comments that Dan made about the flooding on the street. But actually, my wife is a runner, and she likes to run in the area, but she's kind of limited to where she can run. She likes to go down Ancoat Road, but when she makes that turn, there's no sidewalk there. It's extremely dangerous. Obviously, this isn't the concern of the council, but people don't drive at safe speeds on that road, and there's that bend there. And if there was a sidewalk there for her to be on, it would be much safer. I feel that a sidewalk, if you're presenting a new development, I just think a sidewalk would be something that you would want to consider.
Hi, my name is Michael Luters. I live at 391 Giroux, which is on the corner of Giroux and Enclos Road. It's directly across from the new development. And my statement would just have to do with the safety issues and concerns that I have living in that neighborhood. My main concern is that I have children that live at home with me, and I noticed that there is a bus stop right in front of my house on that corner every morning, and like it's already been stated, I know it's county, but there is no lighting out there, there is no sidewalk, and there's a lot of children and young adults in that area. My one son is in a wheelchair, and he can't even access that road. My other son is 17. He has to take that road every day to go to work in downtown at Sponge Docks. But the thing is that I'm worried about when they do build the development, there's going to be a lot more traffic on that road, which is my whole issue is just the safety concern. So, it might be a little more difficult to build a sidewalk there, but is that more important than the safety issues for the children in the area? So that is my concern. Thank you.
Thank you.
My name is Jean Rowe. I live on 331 Anclote Road, which is right on the corner. And I actually have to walk that street every morning at 6:11 a.m. And it's really nice because cars will come down there at 60 plus miles an hour, go around that turn. And I'm sitting there playing Frogger. And it's just not okay. Are you the one who leaves their lights on for us? Yeah, he leaves his lights on in the morning so that we can actually see, because otherwise it'd be pitch black. And when I'm walking, I'm a teenager. I'm in my last year of high school. Sometimes I don't get home so late, and I'll walk to the Sponge Docks or whatever, and I won't get home until it's pitch black. And I'll go down that road, and then there's a hill. Nobody can see. The cars can't see over the hill, so I don't want to walk in the street because I'm going to cause an accident. But then again, if I don't, then I'm going to get hit on the side of the road. And it's a complete disaster. There's sporadically sidewalks, but they're just not enough. I'll take my longboard over to my friend's house, and I'll come back maybe, midnight sometimes. I don't want to get hit. And then the development, I'm sure they're going to have children also. And then I live in a marina, or I live on top of a marina. We have boaters come in from all over the world, and they're always asking us, where are the Sponge Docks? Where's the best places in Tarpon? We tell them, oh, it's over there. They take one look at that road, and they say no. they don't want to stay at the marina. We're losing business, local business, because of that. And then they don't want to keep their boats there because they're afraid it's pitch black. There's nowhere to walk. You don't want to walk in the street, and it would be a complete. I'm sorry. It'd be awesome for the community to put in sidewalks because, like I said, safety is the main factor, and people just don't want to come.
Awesome. What's your first name again?
Jean Rowe.
Jean?
Yeah.
Jean, let me just commend you for someone your age to take the time and get involved and do your civic duty to come in before this board. I know it's not easy, and I, for one, really appreciate you taking the time and bringing up the point about the business. That's something that I hadn't thought of, and I appreciate you bringing that to this board's attention.
Yeah,
Thank
we
you
get
very
boats
much.
from all over the world, and they don't want to stay. So.
Well, you're commended to be commended for coming up in front of this board. Thank you.
Thank you very much.
Good evening. My name is Barbara Schnipper. I live at 1124 Lauren Lane, Tarpon Springs. I just want to thank you for letting us voice our opinions here tonight. I am a biker, and I try to bike wherever I need to go in Tarpon. It's a beautiful town. And sometimes I have to bike on the sidewalks, especially if I were going on Anklet Road. I'd have to take the sidewalk. So that's one reason that I'd like to see a sidewalk put in, because I think that people coming into this community, this new community, probably want to do some biking as well. Hopefully they would, because it's a wonderful way to stay fit, and you save a lot of money not having to buy gas. But that's not the reason I'm a biker. I just happen to enjoy being out in Tarpon, and I also walk in Tarpon a lot on the weekends. But there are a couple of things I wanted to mention. I have a couple of questions that I wanted you to consider. And one is, how does this approach compare with other communities being developed here? Is this very unusual, or is it complying with the normal way of putting in development? And does this plan comply with other neighborhoods in Tarpon? You might want to keep that in mind when developing it. Thank you.
Would anybody else like to speak in opposition?
Good evening. Sorry, kind of got a little bit of a cold there. My name is Jeffrey DeFoe. I live on 1236 Center Avenue. Sorry, I live in 1236 Center Avenue. Couple concerns. One of the biggest concerns is definitely safety in the whole area, not just Anklo, but also going off Center Ave. The condition of our roads on Center is not safe at all, and as this development gets put in, and more traffic goes through, more people will be using our road to cut around to try and cut through. So with that being said, I would like that to at least maybe be looked into. Also the issues with the flooding. Our street, with this other stuff going on, it could really make it even worse than it's been. Also the sidewalk would be nice to have. I've got two kids, two daughters, one's in high school and one's in middle school, and we're between Center Avenue and Grove, and there's no sidewalk there, and there's no light, and like my oldest daughter's in high school, she's there at 6 in the morning, and it's completely dark, and it's not safe at all. There's no sidewalk, and when the bus has to stop in between, they're in the dirt off the side, and if it rains, they're in mud. So those are a couple of the concerns I have. Other than that, though, I thank you for your time, and I just would like it to be looked into a little further. That's all.
Thank you.
Thanks.
Would anybody else like to speak in opposition? Is there anybody here that would like to speak in favor of this application?
This gentleman.
No, sorry, I didn't see you walking up.
All right, here we go. I got 4 minutes. Mr. Armstrong, my friend and sparring partner sometimes, will have the last say. I know, I love it too. First off, Peter Delakis, 514 Ashland Avenue. As Mr. Peters said, I also will say I'm a member of the Planning and Zoning Board, but I am speaking here on my own. Having been a member of the Planning and Zoning Board, I think I have information that has been brought to my attention that isn't maybe as focused on by some of the other members of the public. First off, you have to look at the process. This has gone through the Planning and Zoning Board and the Board of Commissioners, and then it comes to you for a sidewalk waiver, and all the requirements was based on a sidewalk. As it was pointed out, as you mentioned, why wasn't the plan put in or a permit request for a sidewalk? Now, Mr. Peters mentioned elevated sidewalks, possibly waivering the requirement for being concrete. The thing I want to point out, a couple of important things, and I'm going to have to ask you to engage your city attorney. Mr. Armstrong and Ms. Terrapini have made insinuations saying that you must give them the waiver or they're entitled to the waiver. The way the code reads, and unless it's been paraphrased, and Rodney and Mr. Iacobone clarify it, the Board of Adjustment may permit the waiver. It doesn't say you shall, may.
Excuse me, Peter, let me ask you this question. You said this application or similar application has come before you and the planning.
Yeah, it's been before and Rodney may want to elaborate that when you have time for questioning, but yes, it's been to us, and one of the requirements for us was that they have, or the requirements in the finding is that they have to get the waiver from you.
Let me follow up. Rodney, with staff, isn't this kind of backwards?
Not necessarily. What you had, Mr. Coleman, referenced this in the staff report, was that, and again, we did not have a quorum. Well, if you give me a minute to answer the question thoroughly, I will do that for you.
No, I don't need it thoroughly. I just need you to say yes or no.
No, it is not backwards.
Okay. For the record.
Okay. Now, so it's may, not shall, and I will defer to the attorney to let them discuss the may, shall's entitlements. Secondly, all I've heard is impractical. I didn't hear the word impossible. You brought up a point, and it wasn't clear to them that it looks like from the infrastructure they were pre-planning for a sidewalk. Now, the other thing I want to go quickly to your diagram that was given here, where they showed the 7.5. That number, lot 41, is the largest lot on the property. Cut back some of the lot. If you look on an actual site plan, which y'all don't necessarily have, you've got at least almost 120 feet around that edge. At 7.3, you need 15. You give 6.7 back to the community. There are ways to make this work. It's all about, Mr. Peters mentioned, it's about money. It is. Now, let's put it in perspective. Ryland Homes, New York Stock Exchange traded company, billion-dollar company. If they would like to give us the credentials and the background of Ryland Homes, I'm sure they have the wherewithal to do this. Also, when they talk about the Swift Mud, it's not impractical. They talk about mitigation. One of the things we mentioned, and if you look even on this, there is this section here, open space. Through the city, we've tried to get developers to do mitigation within the city. Great. Go to Swift Mud. We haven't seen them really turn down a permit if you give them proper mitigation and tell them you're going to mitigate this section here. Here's where you can open up this canal, maybe put a walkway through here, and maybe a dock or something at the end where people can walk through. And these people have given you plenty of reasons as far as why the safety issues and the lighting. Now, I'm going to put it on the Board of Commissioners. First off, some of you may not be aware of this. Development is coming out there. Where there is county, we have county roads all over the city. Secondly, we have an ordinance in place, and Mr. Iacobone and Mr. Chapman can inform you about it. As development occurs out there, they're going to annex into the city. They are going to be required. This property happens to already be city property. But as properties out there want to develop, to get water and sewer, they're going to have to annex. And eventually, the Board of Commissioners is to have to send Rodney to the MPO with a plan saying we need more lighting and infrastructure assistance in the North County area because this is an area for development. Lastly, this project is at a key point in that roadway. It's not further down Anclote Road. It's right there where the marina is, where the bend is. This is an opportunity to set the sidewalks going out to the future, and at some point in the future we can possibly find some way to connect from Marina Drive there at the southeast corner up to alternate 19. It's not impossible. It may be difficult, but it can be done. I'm sure they have engineers that can accomplish that project. Thank you.
Thank you very much. Okay, I guess anybody else wants to speak in opposition? Okay, is there anybody who wants to speak in favor of this application? All right, I guess at this point, we offer time for rebuttal to the applicant.
And to Rodman, or to staff.
Okay. Is there any preference on who goes first? Is there a procedure on who goes first, staff or the applicant?
What did I read?
Staff goes.
Okay.
Okay. Thank you, Mr. Chairman. Just in rebuttal, again, as most of you know, what we do here at the city is the framework has to deal with standards and criteria. You've heard a lot of public comment about emotional reasons why the sidewalk needs to go in. What I can tell you is the Land Development Code and the Comp Plan were structured this way for a reason, because as they were written, it was realized that there would not always be technically feasible to construct sidewalks. And this Board of Adjustment, since I've been here, has granted sidewalk waivers in the past, so it's not something that is highly unusual to do. Secondly, as was stated again tonight, this is Pinellas County roadway. The right-of-way is under their jurisdiction. They collect transportation impact fees when properties are developed here in the city, and they are mandated to spend them within our transportation impact fee district, which is basically all of Tarpon Springs. So the county has a revenue stream to be able to do some of these things that the public would want. Thirdly, there was talk about flooding on the street. The technical fact is that Linger Longer never had any stormwater attenuation or treatment facility. So whenever it rained, everything came off of that site and went into the swales that are along the roadway. By the site being developed, that no longer will happen. There will be on-site stormwater facilities, so it will actually improve the drainage drainage concerns that people have there. There was talk about safety. Again, there's probably not a bigger champion for sidewalks in the city than myself, but we're not talking about putting sidewalks from one end of Anclote Road to the other. You're talking about a very small segment that would be sporadic and not continuous. You would still have those same issues that you've heard about tonight. And just to elaborate on Mr. Cole's question about the timing of the application, as most of you, some of you know, this was scheduled for December of the board, December meeting of the Board of Adjustment. This board cannot gather a quorum, so we had to defer it. Then we were scheduled again for January, and then we didn't have enough, so we had a continuance. So again, there wasn't an idea to try and
only clarify, we had a quorum last month. The applicant requested continuance because there wasn't enough members for the applicant.
Which is based on the rules of procedure for the Board of Adjustment.
Right.
And I think
Peter, you're out of order.
Continue, Rodney.
And lastly, there was talk about annexation. Yes, the city does have a mandatory annexation ordinance. But unfortunately, I guess I've had the privilege to sit on a countywide task force to look at these cross-jurisdictional issues. And what happens in most annexations, the county would like for you, once you annex a piece of property, to take the road along with it. But that is not the case. When annexations happen, the roadway that fronts that property still remains under the jurisdiction of Pinellas County. The city, does not normally take that right of way. And that's all I have.
Is that the only reason why it went before the planning and zoning before it came before the BOA? Is because there was not a quorum and we did not meet?
No, they had asked.
But why would you make that statement in public forum?
make what statement? I'm stating the facts of how the application came before this Board of Adjustment.
Yeah, but I don't want the public to understand that the BOA did not meet or won't meet. It's not that we don't meet, it's just so irregular that we meet. One time I can remember it was 6 months, didn't have nothing. So when you call us and you send us these applications, we have calendars the same as the city. We volunteer same as most people that sit on other boards. And we want to do our good and due diligence to come out here and serve the community and the people. But to make that statement, I think is disingenuous.
Okay.
If there was a reason for...
This sounds like something that we can make during staff comments and board comments.
I wanted to be on record,
okay.
Mr. Chair.
Would you like to go ahead and provide your rebuttal?
This applicant has listened very carefully to the testimony, right, particularly from the folks who live in that general area. I'm going to address some of the specific points in a few moments, but I'm going to ask Ms. Terrapini to come forward and address really a specific part of the testimony of the opponents. And also, there are some things that we can do in terms of a sidewalk, not an entire sidewalk. That's impractical for all the reasons discussed tonight, but there are certain areas where we think we can help the community. And she's going to address the walkability issue that was raised by some of the opponents, and also offer up a compromise that demonstrates this applicant's good faith and trying to be a good neighbor. And I will close after that with my legal argument that's discussed in competent, substantial evidence of the testimony heard tonight. So, Cindy.
Thank you. I wanted to make a couple of comments. First of all, as we approached this project in the firm, I personally did a study of sidewalks in the Anclote Road area to see where we would connect and how that would work. That was the very beginning of the process, is looking how the sidewalks would work on the site. And what we found is that there are very little sidewalks out on Anclote Road, as I'm sure all of you know from driving it. The biggest concentration of sidewalks is more than a half a mile west of the site at the Office Industrial Park, a good bit west of the site. Someone mentioned here tonight, several people mentioned they lived on Center Avenue. That entire frontage near Center and Grove, all those streets, there's no sidewalk on either side of the road. Someone else mentioned they live in Anclote Isles Marina. Although a sidewalk was shown on the construction plans for that marina, it was never constructed. Why? I don't know. But again, no sidewalk. So there's very, very little sidewalk along all of Anclote Road. I want you all to understand, too, that we not only looked at the sidewalks in the area, but we looked at our specific site and what challenges it had and what opportunities it had. And it has a significant amount of natural features that prevent a continuous sidewalk. Would it really be of any benefit to put in 10 feet of sidewalk or 20 feet of sidewalk and stop for the trees, and another 10 feet or 20 feet and stop for the trees? Not really. That really doesn't serve the purpose at all. And I'd like to speak for a moment about walkability. First of all, walkability is not a criteria for you to review. And while I personally am a walker, and I walk in the Tarpon proper and not the North Bank, I think there are some reasons why their arguments about walkability really don't apply in this particular case. Yes, it's a great goal to have walkability in Tarpon, and I think we all benefit by walkability and by sidewalks. But there's many other parts to walkability besides sidewalks. First of all, as you all know, the north bank of the river was not originally part of Tarpon Springs. It has long been unincorporated. And yes, the city does have it in their planning area, and the annexations have occurred over time, and bits and pieces of the north bank are starting to come into the city. But the city inherited this lack of sidewalks on the north bank of the river from the county. It's not the city's fault. It's not the developer's fault. It's an existing situation. Why the county didn't install sidewalks over time, I can't answer that. Anclote Road, it's even more complicated by the fact that Anclote Road is a county road. Dealing with the sidewalk and the drainage issue, because they go absolutely hand in hand on this particular site and on that entire road, is a global problem that needs to be dealt with by the county. That relates to the flooding issues that have been talked about, and that relates to the swale. It's not something that this developer can solve. All we can do is fix and contain the water that we're currently taking that crosses our site and manage the new water that will be created as a result of our project. We were required to do that. The city will make sure we do that, and SwiftMud will make sure we do that. So again, it's really impractical to think that you can put in a sidewalk with all of these challenges and then have absolutely nowhere to go. But because we would like to, we honestly have looked at many different options, and I would like to present this option as Ryland's good faith to explain to you that they and commit to you they really want to be part of this community and they want to do something that would help. What we would suggest is if you can look at the map again, it's probably easier to explain what's against the map. If you look down in the southeast corner of the site, lot 10, right at the bend, what we would propose is to build a sidewalk. Well, let me go back. Between lot 10 and lot 9 is a secondary emergency access. And it will be constructed and it will be a stabilized base and not full pavement, but it will be stabilized to handle emergency and fire vehicles. That's what you see, that little shading area. What we would propose is probably on lot 10, but possibly on lot 9, on one of those two lots, that we build a sidewalk that would come from Anklet Road, go west across the property, and connect to Street B. And we would have a gate there, or we would have an opening there so that not just people who live in the neighborhood, who live in the subdivision, but anyone who wants to make that path then could come on Street B, walk through the site, and then if you look up at the northwest corner of the site, if you see lots 32, 33, and 34 at the very western edge, between one of those two lots, either between 33 and 34 or between 32 and 33, we would install another sidewalk that would go from Street B north to Anklet Road. So that way people in the area that want to walk generally in a westerly direction can walk on a sidewalk from Anklet Road, which there is no sidewalk there now, walk through this property on the public road system sidewalk and then out the property on the western edge. Again, they're not connecting to a sidewalk, but that's part of the bigger global solution that the county needs to find, and hopefully the city would help them find that. But at least there would be that connection, and we would install that as part of the construction of the project. And I'll be happy to answer any questions about that.
Yeah, Mr. Terrapini, I want to make sure I'm clear. Are you suggesting that you are withdrawing your request for a variance because you plan to come in front of this board or the planning committee with yet different plans that would meet the citizens halfway?
No, I don't think I said that. What I said is tonight we're suggesting to you we still want the waiver for both sections of Anklet Road, but as an option, an alternative, as some mitigation, whatever you want to call it, an olive branch, to show that even though there's no sidewalks connecting on Anklet Road, we would still allow a connection to come through the property in two places and exit out to Anklet Road on the north side so that if and when the county and the city ever get together and do a global solution and put in sidewalks everywhere, there's a connection through the property.
Yeah, it's clear to me what you're suggesting. I just didn't realize that we were negotiating here.
I'm just
if you prefer not to, we can withdraw if that would make you more comfortable. We're acting in good faith, and what I think technically and procedurally you'd be looking at, if the board is so inclined, would be a partial waiver, consistent with the suggestion of Ms. Terrapini. That would be an option.
Actually, it'd be granting a waiver with a condition, and Rodney tells me that would not require, that could be administered. You explain that.
It would not be considered a major modification to the approved site plan.
Yeah, we have done that many, many times on lots of situations where a conditional approval
yes,
that you do something like this, or
if I may, I apologize. The gentleman in the power tie. Can you state your name again?
Ed Armstrong.
Mr. Armstrong. I understand that my fellow members of the planning board are very familiar with you. This is the second time I'm seeing you. Thank you, Mr. Armstrong.
Okay. I'd like to make my closing legal arguments I could, and I will be brief. You guys have been very patient. We appreciate that. It really comes down to the three words that Mr. Yakovone mentioned at the beginning of the evening: competent, substantial evidence. And you've heard a lot of testimony tonight from opponents, but that testimony was about drainage and traffic and lighting and things of that nature. They really didn't address the very specific criteria in your code for a waiver. And what you have in terms of competent substantial evidence in this record is the testimony of Mr. Chapman. You have the staff report from the planning department. You have the verbal testimony of Ms. Terrapini, and you have our application. You have that's what rises to the level of competent substantial evidence. We've demonstrated we meet 2 of the 3 criteria. We only need to meet 1. We have offered up a compromise to show our good faith, and we think that's worthy of your approval. With that, I'd be happy to answer any questions that you have.
Questions?
Oh, yeah.
Okay, go ahead.
But I don't want to steal the floor. I'll let my fellow board members go first.
No, okay, go ahead.
Mr. Armstrong, thank you for your time. And I, for one, want to put on the record that I appreciate you taking the time to teach us uneducated, not legally educated individuals about the law and the burden of proof here and following the law. I really appreciate that. I'd find myself agreeing with you. I think if you remove the emotion and we look at what you're coming in front of this board and saying, that there's an undue, hardship or it's technically unfeasible and the existing right-of-way, I think this board member is having a real hard time getting past the fact that your engineers did not apply to SwiftMud for the sidewalk, but you came in front of the other boards in this city and with the understanding that a sidewalk would be put in.
That's not true at all.
That's not true?
That's factually untrue.
Okay, that's factually untrue. So we'll strike that. But still having a hard time with the existing right-of-way. There's more than enough land here to accommodate the right-of-way. Technically feasible. It appears to me, and from a layman's eye, and I'm still waiting to see something from SwiftMud saying it's unfeasible, or from anything either in our staff report that goes into depth or anything from any engineering firm that says that the existing, particularly the sewer infrastructure, would make it technically infeasible. I've seen plenty of situations around Tarpon Springs where single-family residential homes, where the requirement is to put in sidewalks, where they go around the trees. In fact, it's quite attractive. The sidewalk goes around nice palm trees, and nobody's suggesting, like Mrs. Terrapini said, that we put in 10 feet of sidewalk, stop for the trees, put in 10 more feet of sidewalk, stop again. But I'm having a real hard time, just to avoid the emotional, I'm along with you here, I'm having a hard time with the existing right-of-way when you have plenty of land here to give back to the residents and to the citizens and to the taxpayers for the sidewalk. And I'm having a real hard time finding that it's technically not feasible. So help me with that.
Well, you as a board member, I don't know that I can help you a lot. And Ken, I'm not trying to be flippant with you at all by any stretch. But we think we provided significant testimony from Ms. Terrapini, from Mr. Wagner, and your own city staff. Anything I would say in terms of the topography of the site, the environmental issues, the width of the right-of-way, the fact it's governed by the county, would simply be repetitive. And I don't want to insult your intelligence by going over the same thing again. You're certainly entitled to your opinion. I'm very respectful of that, and that's why it's going to be up. Either a majority of this board will agree with you or not. But I don't know that and I'm saying this very respectfully, I don't know if we have additional facts to bring to this board that we haven't already stated.
Well, I would love to have seen something from the county regarding the swale, something from the county regarding the storm sewer, because it appears to me, it's quite clear on the handout, that the storm sewer and the drainage is already built to eventually accommodate an elevated sidewalk of some sort. It looks to me like concrete based on the manhole there that has...
Are you testifying or are you asking a question? I'm not quite sure what it is.
No, let me clarify. I would like to have seen something a little more in depth from the county, from SwiftMud, position paper from someone other than an employee or counsel for Ryland Homes.
Well, that might make you more comfortable. It's not required under your code that we provide that. What's required is that we meet the criteria for a waiver. We believe we've done that. We believe that every shred of competent substantial evidence supports that conclusion.
Okay. We'll have to agree to disagree.
I think we will.
Okay.
Does anybody else have any questions? Okay. Thank you very much. Yes?
Again, I just feel like I need to reiterate that your decision must be based upon the evidence presented at the hearing cannot be based on speculation or conjecture or evidence not presented at the hearing, and it must be applied to those criteria.
Okay, I have a question for our attorney. There's apparently a disagreement on whether or not this waiver is mandatory if the criteria are met. I'd just like to hear something about that.
Indeed, it says you may grant it if the criteria is met.
That's may or must?
May.
May.
Okay, do we have any other questions?
There may be some legal issues with that, but it does say may.
I think there are, because if it's permissive, then it's not a quasi-judicial hearing.
I understand.
And I know, Jim, you know exactly what I'm getting at.
I know. It's unconstitutional delegation of discretion.
So tell me, what you agree to.
The Constitution says that you cannot delegate discretion to boards. You've got to have criteria. I'm just telling you, the ordinance says may. It should really read must, because otherwise it's giving you complete discretion, and so there's no reason to have evidence.
Mr. Yakavone, can you clarify? The statute says may. In your opinion, is that it really should say must?
No, I'm saying the ordinance says may, and it's my belief that that's an unconstitutional ordinance.
Okay, for those of us that didn't go to law school, what ordinance are you talking about?
The ordinance that we've been talking about all evening, the sidewalk waiver.
I know, I'm just helping you.
Oh, okay, the sidewalk waiver ordinance, 13502, 132.
Which is found where?
In the Land Development Code.
Oh. The Land Development Code of the...
City of Tarpon Springs.
Thank you.
Okay. Okay, that's fine. Are there any other questions following up on that? Okay, we'll go to board discussion now. Does any of the board members like to discuss all of the information?
Well, I'll start it off. I mean, I agree with a lot of the people in the audience here that there's a problem here, but it's not the developer's problem. And I don't think that we should expect the developer to correct the problems caused by or that exist in this city for years and years. It's not his job to do that. I think they've offered a fantastic opportunity here for the city. They didn't have to offer that to the residents of the city. They didn't have to offer that alternative walkway between lots 9 and 10 and 32 and 33. I mean, that seems like a perfect answer for almost everybody's problem. Having this company put sidewalks in is not going to prevent flooding. To me, they've already helped the flooding situation by that large stormwater pond that's sitting there that's not there and doesn't exist in today's world. So I can't see how this developer should be made responsible for correcting problems that really belong to the county. I would suggest that everybody that thinks this sidewalk should go in should talk to the county about it. Go to the county commission. It's their road. It's their problem. There's no lights out there. That's not the city's problem. That's the county's problem. It's not the developer's problem. There's nothing here about adding lights to that highway, to that road. They, to me, demonstrated completely that there's one section that is physically impossible. You can't put a 5-foot sidewalk in a 7.3-foot area. So that's where I stand on this thing, and I'm going to suggest that we approve this.
Any other comments, discussion?
Here. I think we're prolonging the inevitable. Mr. Hasek, I want to make sure that we're clear that we're not discussing lights. We are not in a position in this board, unless Mr. Yakavone wants to disagree with me, we're not in this position as this board to negotiate with this developer about how they might meet us halfway.
I completely disagree with you. We've done it over and over and over. Many, many, many times. We have had many times we have approved variances and on conditional.
Right. Oh, okay. It's my understanding that we can approve a variance with conditions.
Well, yes, this isn't a variance, but it's a waiver. But I think you do have the right to, waive with conditions.
Okay. Go ahead.
Okay, I just want to be clear that, again, if you take away the lights, the bus stop, the flooding, no flooding, I happen to agree with Rodney that the very development of this community and the large stormwater pond will probably take care of all the flooding issues these residents have realized in the past. If you remove all the noise and we talk about what the applicant is asking for, they're asking us to grant a waiver based on not enough existing right-of-way. They have plenty of land to give us the right-of-way, and that it's technically not feasible. It's this board member's opinion that not only is it technically feasible, but the applicant provided us with proof that the infrastructure is in place, except for the trees, and they can give us some more right-of-way so we can go around the trees. I think that's what this board needs to focus on. And with that, I move that we deny the variance.
Excuse me, Mr. Chairman.
Yes.
Before the motion accept.
I'm sorry.
Before you accept that motion.
Yeah, go ahead.
I'm confronted here tonight with application 1262. I'm also confronted here tonight with the Article 1X, Section 132.0008 of the Comprehensive Plan. And I'm also aware of the fact that we, as the body, have the option based on the Comprehensive Plan, and that we can, if it falls within criteria, give relief to the applicant. I'm also very sensitive to all the comments I've heard tonight. And I'm also concerned to safety, concerned to the illumination. But that's not what's here tonight. Here tonight, I have to deal with just that article and on this application, asking for a waiver. As our attorney stated, we can, as a board, grant a waiver with condition. I would like to ask my attorney here, how do we police that condition? How do we know that that would be met at some future date?
Well, if they don't do what they said they'd do, then they'd have to put in the sidewalk. And staff, Mr. DePasqua's department would make sure that it's done.
Is there some kind of timeline?
Actually, not on a waiver.
Not on a waiver?
I don't see, I don't know, Rodney, maybe you can help me on that.
Mr. Cole, the condition of approval of the site plan was that the applicant apply for construction permits within 1 year of the date of approval. So they have until, I believe, December 18th of 2013 to apply for their construction permits. And at that time, we would ensure as Development Services staff that whatever the board decides tonight will be carried through during the construction permitting phase of the project.
Okay. Thank you.
Okay, any other discussion or comments? Okay, state your motion again for me.
I'd like to move that we deny the variance request.
Okay, I have a motion to deny this request for waiver. Do I have a second? Okay, so I don't have a second.
I move that we approve, let's see, what's the number? I make a motion we approve application 12.62 as written, with the exception that the developer will provide a sidewalk between Anclote Road and Street B located between lots 9 and 10, and another sidewalk between Street B and lot 32 and 33, or lot 33 and 34, at their option, which one of those two they would prefer to use.
with or without the condition?
Yes, that's with the condition that they provide the sidewalk.
Yeah, that's with that
So I'll
condition.
just finish. We have a motion on the floor, conditioned as was proposed by the applicant, to provide sidewalks between Anclote Road and Street B within the community, as has been previously stated on the record. Okay, I have a motion. Do I have a second?
Second.
Okay, I have a motion and a second. We'll have a roll call vote.
Was that Mr. Cole that, of his writing, was that Mr. Cole that seconded?
Yes.
Okay. Is that Karen? Mr. Cole?
Yes.
Mr. Hassick?
Yes.
Mr. Pallarino?
No.
Mr. Darby?
Yes.
Chairman King?
No. Okay, the request for waiver, the application for waiver passes. I guess we're on to the next application, unless we have any unfinished business on that one. Application 13-07, applicant's name is Allen. Move on to staff presentation.
Well, any ex parte communications regarding this application?
Have there been any ex parte communications by any board members regarding this application? None.
And I guess we need to swear.
Okay, is anybody here going to provide testimony on application 13-07? Could you please stand and be sworn in? Anybody who's going to?
Do you swear, raise your right hand, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? And affirmations all around.
All right, now staff presentation.
Thank you, Mr. Chairman. This is application 13-07. It's a variance to reduce the side yard setback and to allow an AC unit to be placed in the required front yard setback for a detached garage that is under construction. You have the code requirement there in your staff report, which requires a minimum of 10 feet with a total of 25 for both side yards for new structures, and then the code section dealing with air conditioning units. The property is located at 720 South Florida Avenue and it's in the R100 zoning district. Give you a little background on the application. The applicant's contractor submitted a building permit on October 29th of last year to construct a 627 square foot two-story masonry detached garage. The permit was approved on November 14th, and construction of the garage commenced shortly thereafter. The construction of the garage proceeded through the city's inspection process, and you see the milestones that were achieved. I'm not going to read those off. In January of 2013, it was brought to our attention that the garage appeared to be too close to the side property line. Upon closer review of the building permit and the plans, we discovered that the permit was approved in error, and the garage was 2.3 feet too close to the side property line. It's our understanding that furthermore, the south side neighbor did not want the AC unit to be placed at the side or rear of the structure because of noise concerns. Since this requested variance was the result of a mistake from staff, the city is bringing this application forward on their behalf to correct the error. TRC reviewed it at the February 14th meeting and had no objections. As for standards for review for variances, we've determined that the need for the variance arises out of physical conditions that are unique to the specific property. The applicant followed the proper procedures, and the error was only discovered after the garage was substantially complete. The error has resulted in a non-conforming situation whereby the only legal way to issue a certificate of occupancy for the structure is the granting of the requested variance. The conditions of special circumstances associated with this property have been created by, again, the error in approving the building permit with the garage 2.3 feet too close to the side property line. Little enforcement of the land development code requirements will require the detached garage be demolished and rebuilt in a location that conforms to the regulations. It's our opinion that this is clearly unreasonable given the applicant followed the proper procedures and assumed that the building plans met all codes and regulations. The granting the variance would not extend a special privilege to the applicant other property owners with similar circumstances would be extended the same courtesy. And lastly, it's our opinion that the request would not diminish property values or alter the character of the surrounding area. As far as public correspondence, we have been in pretty much constant contact with the Southside neighbor, Mr. Brower, who lives at 740 South Florida Avenue, who is objecting to the request. I've also provided a letter that Mr. Brower emailed to us this morning. It's this letter here. As far as the staff recommendation, it is our opinion that the request has met the criteria. Therefore, the staff recommendation is to approve the request to reduce the side yard setback from 10 feet to 7.7 feet and to allow an AC unit to be placed in the required front yard setback for a detached garage that is substantially complete at 720 South Florida Avenue. I've provided photographs of the existing garage taken from South Florida Avenue. I've given you an area map and an aerial photo of the applicant's property, zoning map, a feature land use map, and a couple of survey documents. One is an enlargement of the boundary survey for the subject property, showing in general terms where the AC unit would be or could be placed. And then the last document is the boundary survey of the property at 720 South Florida Avenue. With that,
I just want to point out a special part of your variance criteria that applies to this. Besides the normal variance criteria in 215.02 of the Land Development Code, there's a 215.02E. It says, in the highly unusual circumstances where, 1, the property owner or contractor has made a mistake in the construction of a structure, and it would be economically impractical to correct the mistake at the time it was discovered. 2, the appropriate building permit or other use permit has been issued. 3, such mistake could not have been avoided by the application of normal construction or business practices. And 4, such case is proven before the board by competent substantial evidence. Then, and only then, may the board grant the minimum variance that will achieve a result that is fair to the applicant or the public alike. I only point that out because that's specifically applicable.
Mr. Yasmo, did you provide this? You did from municicode.com. Do we have the version that's the official version from the government website or printout?
Municicode.com is the official version.
This is the official code. Okay.
Did you give them that language? Yes. Oh, okay. I'm sorry. I didn't know you had that.
Okay. Could the applicant come forward and give their presentation?
Todd Spinlaw, I'm the owner of Orange Blossom Developers. I'm the builder that is actually doing the garage. I really don't. I live in Tarpon Springs, 1560 McChesney Drive. I don't really have a presentation. Obviously, we permitted the job, went through the proper procedures, and it got permitted with the wrong setback. And I proceeded with construction, obviously not knowing there was any problem until the city actually let me know that they had made a mistake.
Does the board, anybody on the board have any questions for the applicant? Okay. Anybody against this application can come forward now.
Good evening. My name is Scott Brower. I live at 740 South Florida Avenue, Tarpon Springs. I'm here, number one, not because I want to be here. I was placed in, I think, this predicament, not by my own choosing and not by the choosing of my neighbors, Dr. and Mrs. Allen. Be that as it may, we've been neighbors for 30 plus years. We bought the lot, 3 acres together, split it, and built our home. Our kids grew up together. And I don't like being here having to voice my displeasure with the incorrect setback. But I just heard something that is not true, that the error was not discovered until substantially complete. And that's not true. Probably, and I can't give you the exact date, probably in November or December, when the footer was being put in. My driveway is immediately to the south of this borderline. I walked out and looked at the footer being dug, and the next morning as I drove out, there were three gentlemen there. I believe this gentleman was there. And I stopped and got out of my truck, and I introduced myself, and I said, wow, this looks awful close to the property line. Are you sure you have the right setback? And the response was, yeah, the setback's 7.5 feet. And we came back a couple inches, and everything's fine. And I said, are you sure that the setback isn't 10 feet? And the response was kind of abrupt and said, I'm a builder. I do this all the time. I know what I'm doing. I said, okay. I got back in my truck and went to work. So it could have been remedied if someone had checked or someone had gone back, probably the builder in this case. So I'd ask him point blank if he was absolutely sure. And he told me in no uncertain terms that he was the expert, he was a builder, and he knew it was right. So, here we are tonight. He wasn't right, and I was right. And my property has been damaged. When you drive into my driveway on an 1.5 acres on the Gulf of Mexico, a very, I think, valuable piece of property, as well as the Allens, the first thing you see is this building hunkering over my property. I want to pass out a few things for you to look at. And I want to probably draw your attention, and it's probably not necessary, but I want to do this if you'll indulge me for a minute. There's three things I want to put on a record that I think are critical. The first is marked A, and it talks about variances, the definition of a variance. There's an area variance and a use variance. An area variance is usually not controversial because it is generally granted due to some odd configuration of the lot or some peculiar natural condition that prevents normal construction in compliance with zoning restrictions. That's the definition. There is no unusual configuration or odd configuration of the lot. If you go to the next page, B, the lot size is 126 feet of frontage and 625 feet deep. There's 126 feet of frontage that garage could have been built in. When you take the setbacks out, you still have in excess of 108 feet that garage could have been properly built. So there's plenty of room to build it, and there's no odd configuration of the land. Next, if you would please look at what I've noted C, which is from your Board of Adjustment application. It says Board of Adjustment review standards. The board shall grant no variance unless all of the following standards are met and are proven by competent evidence.
Sir, I'm sorry, you've reached your 4 minutes. If you could I
please have another minute or two?
You can have another minute, but just try to wrap up what you're saying.
Okay, if you can read number 1, the need for the requested variances arises out of physical surrounding shape, topography, conditions, or other physical or environmental conditions. That's not the purpose of this variance. Item 2, the conditions or special circumstances peculiar to the property have not been self-created. Have not been self-created. That means You didn't cause it. The applicant didn't cause it. The applicant did cause it. This application is not a true application. They shouldn't have signed it. They don't meet the criteria for you to grant a variance. So I would ask you to not grant a variance. I also want to pass on to you, in the past month, this project has not stood idle. It's been worked on every day. Here's some pictures of the air conditioning unit that's already placed where they're asking you to approve it. It's been there since Monday. I can't guess what the reason for that is, but I think the applicant thinks you're a rubber stamp.
Okay, thank you very much, sir. Is there any questions that any of the board members have for?
I'm sorry?
I'm asking if anybody has any questions for you.
Sure.
Okay, there's no questions. Thank you very much. Is there anybody here to speak in favor or against? Okay. I guess we'll move on to discussion on this application.
Yeah, I do have a question. I should have asked when you were standing up. You sat in the last discussion we had about the development, and you may have noticed that there was a compromise made. Is there any way a compromise can be made here with that air conditioner? Be put in a different place so it does not impinge on your rights of quiet?
I'm okay with the air conditioner.
Oh.
I just wanted you to know that they obviously don't care if you approve it or not. They've already done it. That air conditioner's hooked up.
Well, it could be moved. I mean, if this variance is turned down, it'll have to be moved.
I agree.
So my question to you is there any opportunity for some kind of a compromise in that condition?
Yes, there is. And I talked to Dr. Allen yesterday and said, put a call on your builder. Let's you and I and the builder meet tomorrow night at the house and see if we can come up with something. The response was the builder was too busy to meet with me.
Okay. Do we have any other discussion for this application? If not, do we have a motion?
Well, I have a question here. To our attorney, I guess, or to Rodney. What happens if this is turned down? Does this mean that building has to be demolished?
Yes. Okay.
I have a question. Why is that a concern?
Who would pay for it?
Who will pay for the what?
The applicant, or not the applicant, yeah, the builder. Either the builder or the homeowner, property owner.
Mr. Hassick, you asked that question because you are going to take that knowledge into account when you decide either way?
I'm sorry, I can't hear you.
You asked the question, what happens to the building if the variance is denied? I'm asking if you ask that question so that you can weigh the emotional aspect of the property needing to be destroyed in your approval.
I was curious what the process is.
Okay.
Is there any other discussion? Okay, do I have a motion on this application? Somebody would like to make a motion?
I'll make a motion that we deny the variance requested.
Okay. I have a motion to deny the application for variance. Do I have a second? Okay, the motion dies for lack of it.
Floor is closed to.
Well, hold on. No, I'm sorry. We're getting ready to vote.
The problem here is that this board seems to be okay with variances with conditions, and we can't make an emotional decision on a required. Everybody who builds in Tarpon Springs has put a sidewalk in, so we'll ignore the handicapped, the children who are waiting. We'll ignore all that.
That's totally out of line.
No, I'm just saying, it seems like now this board is now we're going to grant a variance after we've built.
I will make any motion I choose to make, and I make a motion that we approve.
Okay, I have a motion to approve this application. Do I have a second?
Second.
I have a motion and a second. Let's vote.
Mr. Cole?
Yes.
Mr. Hassick?
Yes.
Mr. Talarino?
No.
Mr. Darby?
Yes.
Mr. Chairman King?
Yes.
Okay, application 1307, has been approved. We'll now move on to staff comments according to the agenda. Staff have any comments?
I guess, if the board so chooses, do you want to have your election of officers, at this time?
Okay. Yeah, we'll go ahead and we'll have an election. Are we overdue for an election of all officers?
Normally it's every year, every
Okay.
January.
Okay, which we haven't done. Okay, so, I guess I'll just take nominations.
I nominate Matt King for chairman.
Second.
Third.
Okay, do we, I guess everybody wants my job. Do we,
Mr. King, do you want to be the chairman?
yeah, that's fine. So now we have a roll call vote on that? Is that? Yeah. Usually how it happens? Okay, so then we'll have a roll call vote. I have a motion and a second for...
Gentlemen, outside, please. That was my attorney voice.
You have to forgive me. I didn't know we were doing this tonight, so I didn't have sheets ready, so I have to handwrite everything. So just give me a... So I have Mr. Hassick nominate Mr. King as chairman and Mr. Talarino second the motion.
No, he's the only one who didn't second it, actually. Mr. Darby.
Oh, I'm sorry. I didn't get, I'm forced it. Somebody thirded it. I should have forced it.
I'm sorry, you sounded alike. I wasn't looking.
I remember that.
Mr. Cole?
Yes.
Mr. Hassick?
Yes.
Mr. Talarino?
Yes.
Mr. Darby?
Yes.
Would you like to vote, Mr. King?
No, it's okay. All right, now, nomination and second for vice chair.
Mr. Chair, I nominate, Mr. Hassick as the VP.
I have a nomination of Mr. Hassick for vice chair. Do I have a second?
How does that make you feel?
Do you want to be vice?
You want to do it, John?
Do you want to?
No. You?
That's not what...
There's a motion on the
Could
floor.
you delay that for a second, please? Could you delay the vote a second, please?
Yes.
I don't.
We've got some back office politics going on here. Are you okay? You smoke filled rooms.
As long as you're gonna be here.
No, I said, or you and North
That's the question. Mr. Darby is the alternate currently. So.
Okay, end of discussion, okay.
Hey, as a matter of procedural, Mr. Darby is an alternate member, is that correct?
Yes.
When was Mr. Darby, when was his paperwork completed to become a member of the board? Do we know that?
He was just appointed by the city commission in the last couple of weeks.
Last week, correct?
Yeah.
Okay. The very first application we saw tonight was a continuance. Testimony was received at that time by citizens from Tarpon Springs. Is that correct?
What do you mean from at the
No.
last meeting?
At the last meeting?
No, we didn't receive testimony.
I thought we did. I thought we had some people talk and then we granted a continuance.
So we had discussion on whether or not to grant the continuance. Somebody discussed whether or not we could accept testimony at that time. We said no, we wouldn't accept any
Oh, I thought
testimony at that meeting.
Mr. Marty Peters had given testimony at that time
No,
as a matter of record.
He gave us advice on accepting testimony at that time that we decided we weren't equipped.
Mr. Yakavone, since this board heard a motion for continuance on the application fee last month, the one application fee that we granted a continuance and that first applicant was then heard tonight, how does that affect Mr. Darby's ability to vote on that?
Well, I don't think it affects his ability at all. There was no evidence taken according to what I'm hearing, so.
Okay, if there was, if we see there was evidence that was a matter of the record, how does that affect it?
Well, I'm not even sure it would. In my mind, it's almost like a rehearing, a total new rehearing.
Right. I mean, everybody who spoke regarding whether or not there should be continuance granted. We specifically discussed whether or not we were going to accept testimony that evening, and we decided that we were not going to accept it.
I agree 100% with you.
As I recall, Mr. Peters talked about his experience at a county meeting where they didn't allow or did allow public comment.
And one of the reasons we decided not to accept testimony was the attorney for the applicant had already left. So, I mean, there was no testimony officially accepted. All the discussion was whether or not to grant a continuance. Whether or not they said anything, I don't know, but there was no testimony officially received.
Mr. Giacomo, would you let us know at the next meeting when we approve the minutes whether or not any of those comments that were made last month are a part of the record for that particular applicant?
I'm sorry, I missed.
This question was Mr. Giacomo.
You want me to review the...
Yeah, is that a request I can... I'm sorry?
You want me to review the tape to see if evidence was presented?
Please, if you would.
I mean, I don't want to continue this meeting any longer. We have to, but I mean, either we accept the testimony or we didn't. Whether or not somebody got up and offered their opinion on something is kind of irrelevant if we weren't sitting in an official capacity to receive.
I agree with you.
Okay.
Right. That's my concern. If we were in official capacity, we had a quorum in that time. We did not have a majority of the members. My question is whether or not Mr. Darby could vote.
Well, my understanding, whatever the comments were, the vote was to continue the meeting to have more members here to hear the issue. So I look at this as being a complete retrial. In which case, whatever happened before is irrelevant.
Thank you for clarifying. I understand. Thank you.
Okay. All right. We are still trying to elect a vice chair.
There's a motion on the floor by Mr. Cole to nominate.
Would somebody like to be vice chair? Somebody nominate somebody?
I still have a motion on the floor.
I don't remember.
Okay, we have a nomination, Mr.
I have a nomination on the floor.
We need a second.
I second the nomination.
Okay, so we have a nomination of Mr. Hasek and a second. Could we please have a vote on that?
Mr. Cole?
Yes.
Mr. Hasek?
Yes.
Mr. Talarino?
No.
That means you got to be on time.
Excuse me?
No.
No. Mr. Darby?
Yes.
Chairman King?
Yes. Okay. Board comments?
Oh, you going to take care of me? I'm taking care, right?
Yeah, you're
taking care, right?
Okay.
Just a question about the language in the ordinances that says may. Is there going to be some effort to remove that bad language? I've seen it in several places. Yeah. Thank you.
Thank you.
Okay. This meeting's adjourned. Thank you very much.
We had more